To frame this panel, the EU's General Data Protection Regulation went into effect this year, and there was a state bill, the California Consumer Privacy Act, that also went into effect. And about 2 weeks ago, the Trump administration came out and tasked NIST, the Department of Commerce, with creating a voluntary privacy framework very similar to the NIST cybersecurity framework. So privacy is really at the forefront of the national policy discussion right now. On top of that, this year, all 50 states have some sort of bill related to data breach notification. And that's actually raises the question of federal preemption, and what that might look like is actually a comprehensive piece of privacy legislation. So thank you to Colby back there. We have a poll for you all that'll be live for the next 10-ish minutes that asks the question that's at the heart of this panel. So go ahead and add your voice to that. So in this panel, we're going to discuss exactly what the consequences of such comprehensive federal privacy legislation might look like and what the policy landscape is right now. So I would like to start by asking each of the panelists, in your current role, how do you approach thinking about comprehensive privacy legislation, and how do you approach thinking about these issues? So let's start with Chris.
Sure thing. Helps if I turn it on first. Thank you, Anne. So as in the introduction, my name is Chris Riley. I'm the Director of Public Policy for Mozilla, the nonprofit organization and maker of the Firefox web browser. We are a unique organization. We are structured as both a corporation and a foundation. I promise I won't give too much context, but just a little bit so people who haven't heard of Mozilla know where we're coming from. We're routinely the tech company that likes privacy law, so that's the, the hat that I will be obviously wearing as this conversation continues. And from that perspective, we've been pleased to see the introduction and the adoption of the General Data Protection and Regulation, the GDPR. We've worked in Brussels on the e-privacy regulation as well, which is still very much a work in progress. We were supportive of the California State Privacy Bill that came out. We're working very hard in India to try to get a national data protection law adopted there, and have been supportive of most of what we've seen in the draft for that. I work very closely with my colleagues in legal and compliance at Mozilla as well to make sure that we, as a product company, as a company with services, with hundreds of millions of users around the world, we have to be in compliance with these things too. And we have our dialogues and our pathways, but we believe that privacy is fundamental, and one of our original 10 principles of our manifesto is that a user's privacy and security on the internet is fundamental and must not be compromised. So we come into this from a very strong perspective of supporting privacy rights and protections for individuals, and working to make sure that the laws that put those into practice are sensible technically and realistic and feasible to be implemented.
Thanks. Jamie?
Great. Thanks. So Jamie Boone with the Consumer Technology Association. I focus on policy, both at the federal and increasingly more and more at the state level. And so the Consumer Technology Association is the largest tech trade association in the world. We own and produce CES, Consumer Electronics Show, about 2,200 member companies. And actually, 80% of our companies are small businesses. And when we're thinking about this issue in particular, our goal is to make sure that those voices are also represented, that they're also at the table. When we're thinking about how startups might be impacted by privacy legislation and what that impact could be on innovation, we take that really seriously, and we feel that's our responsibility to make sure that we're representing that view as well as our many other large companies that we all know and love and work with closely. So it's a big issue, and there are a lot of different players and a lot of different companies that are going to be impacted in very different ways.
Thank you. Neil?
Hi, thanks for having me. Neil Chilson. I'm from the Charles Koch Institute, but before that I was at the Federal Trade Commission as the acting chief technologist and as an attorney advisor to acting chairman Olhausen. So I've seen this issue from a couple different perspectives, but at the Charles Koch Institute we're really interested in creating a culture that embraces innovation as well as a regulatory framework, a policy framework that focuses on defending individual rights and redressing consumer injury. So we want a policy framework that allows innovation to continue and a culture that embraces it. What does that mean in the privacy space? I think there's two ways. When you think about how privacy applies to government, and we heard a lot of mixing on the previous panel about government power versus corporate power. So at the Charles Koch Institute, we are very big fans of technological and legal protections for privacy rights vis-a-vis the government on how government can collect and use information against individuals. On the corporate side, we really want to make sure we have a culture of innovation, and that means maximizing the ability of consumers to make choices, not just about privacy, because consumers care about privacy, but they care about a lot of things. And so they care about efficiencies, they care about convenience, they care about price. So we want to make sure that consumers can make the choices across all of those dimensions that make the most sense for them. And that means if government puts the thumb on the scale for one particular vertical or one particular quality over another, we have questions about how that will play out for consumers. And so to maximize consumer choice across all those dimensions, we advocate for a framework of permissionless innovation, one where the government's role focuses on addressing consumer injuries that happen rather than trying to predict what might happen in the future and design the world around that prediction. And so that's kind of our take on it. It's a similar take to what I took at the FTC, which is part of why I moved to this new role. So.
Awesome. Thanks, Neil. So let's start with asking a question about the California privacy law that passed this year. Specifically, this is relevant to many people in this room. But what are some of the provisions of that law, and how is that law going to affect, say, small businesses or other people that are dealing in this ecosystem?
Do you want to start? Sure. So yeah, from my perspective, the California law so a intense, kind of insane process. With the starting with the ballot initiative and then last minute legislative push to get something done. Before getting to that point. And I think it did a disservice to the innovation economy, to the state. I think rushing something through at the last minute because of pressure from one individual was not productive or helpful. I think that's part of the reason you see a delayed implementation date of 2020. Why you see concerns from both sides, from the industry side, concerns from the consumer protection side. There were a lot of very confusing provisions in that bill that really made no sense. And I think we're going to see the next year a lot of efforts to make changes, both just technically already, just to bring some clarity to what was intended, but also to tighten up that language. Very, very broad definitions of personal information. Which is, I think one of the top concerns from our perspective, and we're concerned about the smaller businesses that will be impacted by this, will be captured by this. I think 50,000 IP addresses is the minimum of what you hit. If you hit that, that's 137 page visits a day, and then you're impacted by all of these different requirements on how you have to track data, how you have to report on the data that you're using. Complying with consumer requests for deletion, for amending the data that they have. So it's a very, very complex piece of legislation that I think is going to take a lot of time to understand. I think a lot of industries, a lot of businesses are just starting to try to interpret it and what it means for their businesses, but there's a lot that's going to be determined in the next year, and then with the rulemaking process from the Attorney General that you're gonna see a lot more about this in the next year.
Chris, do you have anything to add?
Sure. So from Mozilla's perspective, we're, although recognizing let's call them the complexities of the process that led to the adoption of this law, we're at least happy to see progress on privacy law in the United States, some significant momentum that we see now in part because of the California law, in part because of the GDPR, in part because of growing consumer awareness of what they believe should be their rights and their understanding and their ability to have access to and control over information that is stored about them or generated by them on online platforms and services. So I think that we are, on balance, happy with the outcome. We recognize that there is a healthy delay before implementation and that there are technical fixes that need to be made in order for this bill to really achieve its potential for promoting privacy for internet and technology users. I'll call out a couple of good things in the bill from our perspective. Giving users more information on data that's being collected about them is something that we regard as a critical component of the GDPR in Europe and core to what makes it a good bill in our view. Giving opt-out for selling information to third parties is something that we believe is a fundamental positive piece of this. Giving users access to data about them with rights of correction and deletion. I note Jamie's concerns over the costs of implementing that. That's part of the GDPR as well, and not all businesses will have users in Europe and will need to find themselves complying with that. But it's part of the trend of privacy law as it evolves around the world, and we believe that's a good thing and part of what users should have as part of their fundamental privacy rights. There's a private right of action subject to a 30-day right of cure, which we thought was a good way of balancing some of the enforcement challenges that will come from this. So we did see a lot of good things. We want to see some of these technical fixes pass through, and there's always the chance that, it looks like I'm winning in the Twitter follower count, by the way. I just wanted to give that a call out. There's always a chance that comprehensive federal privacy legislation ends up coming in and preempting this, so we're certainly keeping our eyes on that development as well.
I think I would just add to the process concerns. I mean, we heard a lot of talk today during one of the panels about how Congress needs to have more expertise in order to be able to deal with these issues, and that the most sustainable, best laws come out of deliberative process. This process was the opposite of that, and it's very interesting. If you have concerns about how legislation should represent the views of individuals, this was, in some sense, the view of one individual that drove this, who was able to fund a campaign that moved the ball and was very successful from his viewpoint. But you have to ask if that's the way that we want deliberative, democratic legislation to proceed. On the provisions in the law itself, I think it's so complicated. There's so much in there that I think we'll figure out. There is undoubtedly some things that are beneficial or sound like good ideas, but might be hard to implement. And there's lots that contradicts other provisions in the law. And so I don't think this law is really a template for successful privacy legislation. I think it's an example of outcomes from flawed procedural lawmaking.
Sure thing. So, Chris, you brought up one of the interesting provisions of the GDPR is to allow consumers to actually download data that is their data that's collected by whatever app or service they're using. So there's actually a lot of unintended consequences that result from some of these provisions. I just saw on Twitter the other day that there was a woman whose Spotify account got hacked, and her entire music history was stolen by whoever hacked that account. And so some of these provisions, while they seem good for consumers, might actually cause harm or unintended consequences. Does anybody have any examples of how that might also be the case?
Sure, I'll just say from a, more generally, we're, you can look at data breach legislation. We have, 47 states with 47 different data breach notification laws, all with different requirements. That is confusing for consumers. That is confusing for industry. That's confusing for small businesses, for retailers. It's just across the board not a great idea, not a great model. However, that's been the world we live in for the past, 20 years. We've been trying to get data breach legislation at a federal level to have one national standard to make it easier for consumers. So I think that, you'll see a similar model with privacy legislation. If we go down that same path of having a state-by-state approach, is very difficult to have consistency and very difficult to have a clear understanding of what is out there of yours, and who knows what and what state is requiring what and what enforcement. It's just a very convoluted process. I think will just lead to more confusion.
I think I would just push back a little bit against some of the language in the question. I think I generally agree with the question, but the language about downloading data that a consumer owns or data that is the consumer's data. I think that is a very common sort of metaphor that we use about information. But when we think about privacy, we should take a step back. What is privacy? In some ways, privacy, a state of privacy, is a limit on information flows. It's where we have somebody making a choice about how to limit information that's going between two entities. We live in an economy where information is essential. I mean, this has always been the case. Communication and information are essential to human flourishing. They're the way. That's the way that we communicate. It's the way we transact. It's the way that we get to know each other. It's the way that we build a society. We need to think a lot about how we set up structures that allow people to share information that they want to share, and not stop the people who want to do that from being able to do that. And so the privacy law, a lot of it is about how do we set those defaults. And from my perspective, the right way to do that is to push the decision-making down to the people who know what they want the best, which is the consumer. And the way that we do that is, and again, this isn't just about making privacy choices. This is about making choices about the products that they use across the board. And those consumers often are much better suited to make those decisions than somebody in the California legislature or somebody in the DC legislature. And so when we think about how to design the frameworks in which people are going to share the information that is super important to share, we need to make sure that we're not cutting that off for a big chunk of individuals. And
so just to build off of that, consumers don't have the ability to exercise choice in that sense if they don't have tools made available to take their data off of that system. If it's trapped into a walled garden, then they can't exercise the kinds of consumer choices that you're talking about. That having been said, there has been a trajectory towards offering this even in the absence of legislation. I think the tech industry has gotten much better over the past few years at offering effective data download type tools. Maybe they've been doing that because they've been anticipating the GDPR or legislative intervention that would require it. Maybe they've just been doing it because their customers are asking for it and they want to give them that option. But I think that that's a very, very fundamental piece of the balance that we need to have in place between users and technology companies is the ability to take the data that you have put into the system out at some point in the future. So I'm very comfortable with that. I acknowledge the security risks that can come from that. I think that's a very illustrative example. And it's very important to pay attention to the authentication and verification procedures that are being used in order to make sure that it is indeed the user. Is that going to be foolproof? No, it's certainly not. There will be breaches. There is no such thing as a perfectly secure system. But I think that it can go a long way to minimizing the possible harm with proper authentication verification systems. And I think that the trade-off is necessary. The little bit of extra risk that you might incur is a fundamentally necessary piece to give that kind of consumer choice, to let that user take their data out, get it off the platform if they have decided they no longer want their data on that platform, and to reference the competition panel earlier, ideally be able to put it into a different platform and switch their services over to walk with their feet. My brain is blanking on the expression, move with their feet, choose with their feet. Anyway.
Vote with their feet, yeah.
Vote with their feet. Thank you.
Sure, it's a great point. So bringing up last panel, I liked that it ended on the question of, we've sort of focused on the US in this discussion, but in the space of privacy law, there is a huge precedent in the EU for having a different approach compared to the US. So my question to you is could you sort of enumerate what the differences in the approach is and how that might affect the conversation regarding comprehensive privacy legislation in the US?
Well, I'll just jump in and talk about the U.S. approach because that's a framework in which I did a lot of work. I think it's often, and particularly in Europe, it's often perceived that the U.S. is the Wild West, that we don't have any privacy protections in the U.S. And that's not correct. First of all, our protections against government invasion, while imperfect, are quite a lot stronger than protections in Europe for the same sorts of issues. On the commercial side, we have a large number of sector-specific laws, GLB for finance, we have HIPAA for health information and health providers. We have bills like the Children's Online Privacy Protection Act that sets specific standards around children's information. And then outside of those areas, we have a general federal consumer protection agency, the Federal Trade Commission, that has been, if not the most active privacy enforcer, privacy and data security enforcer in the world, definitely in the top two. I would say it's almost certainly the most active one. Over 500 privacy-related cases, 50 that are directly, just solely privacy online cases, 60 data security cases, and then a whole bunch of things that work in similar areas, like the GLB laws and the COPPA laws that I talked about. And so there's quite a lot of enforcement in this space. There's quite a lot of federal action. And there's a lot of soft law. Adam talked earlier about soft law and these norms that allow processes to evolve without trying to over-design a system that nobody can really predict where it's going. The U.S., that has been the U.S. approach. It's backed by the FTC stopping deception and stopping unfair acts and practices. But on top of that, there's a lot of soft law that allows innovators to create something, and if they create something that doesn't injure consumers and they don't deceive them, generally, that's okay. And I think the results, you can see them. You can see how the U.S. has been successful. You can see why many of you in this room and many in this area have been able to develop companies that rely on data because they're serving consumers. And the reason that the U.S. has been so successful in that space is because we've had the ability to innovate without asking permission from the regulator first.
So if I could go next, I'll let you clean up. I'm certainly a big believer in the power of soft law. I'm also a big believer in the Federal Trade Commission, which I think does fantastic work. It's certainly my view that we don't have enough from that in the American legal environment today. But setting that even aside for now, comparing it to the European approach, the General Data Protection Regulation replaces an earlier directive. In the EU legal context, just for those who haven't worked in that environment very much, a regulation is more specific than a directive and has specific binding pieces that affect all of the 28 member states of the European Union. A directive, although it has a force of law and a piece to it, is intentionally designed to allow each of the European member states to adopt their own interpretation. And one of the dynamics over Europe over the past few years has been a greater political tightening, or at least an effort at greater political tightening within the European Union. It's certainly had its blowback, most notably in Brexit. But I think an impact or an outcome of that evolution has been the Data Protection Directive, the e-privacy directive, also known as the Cookie Directive, more colloquially. They've been evolving towards more of a regulation-style approach, trying to achieve greater harmony in how privacy law is adopted and enforced across the different member states. There are still individual data protection authorities within these countries that have their own styles and their own approaches, but it all at least rolls up to the same set of regulations and the same set of specific approaches that are in the GDPR after its effective date earlier this year. So from a substantive point of view, certainly there are differences. The GDPR includes many of the elements that I articulated as good parts of the California privacy legislation. It's setting an example for the rest of the world right now because of how specific it goes to the digital environment. So by addressing specifically the collection and use challenges that are faced by users in the internet and of technology today, the EU has set a precedent. The EU has set a major precedent, one being followed by India, that I believe will be followed over time in Africa and in other countries around the world. And not only is it a precedent, the global internet means businesses need to reach European citizens. And the GDPR sets a standard for that, for how good your data protection law needs to be in order for you to do business in Europe. So they have these adequacy and these data transfer thresholds and so forth, and a very, very high profile privacy shield conversation between the US and Europe, one that is still very much ongoing. And it's an open and I think challenging legal question to say whether privacy law in this country is good enough now to meet the standards needed in the EU for us to continue to have the kind of global internet, global business, and global data flows that we all in this room want to preserve.
Jamie, do you have it? Yeah.
Yeah, sure. So I agree with points that both of you made. Especially Neil. The FTC process has worked well historically, and we have seen innovation in this country far beyond any other. I mean, 50% of the world's unicorns are in the United States, and I believe that the reason for that is because we've had this hands-off, permissionless innovation approach. However, with Europe's new approach with GDPR setting this new standard for the rest of the world, I think there's going to be more of a shift in the country, in the U.S., to not get there, because I don't think it's the right model for the United States, but I think that there are elements from that you'll start to see be considered. I think we're seeing more of an awareness from consumers on their data and more interest in what's happening with their data. And that's not a bad thing. That's a good thing, I think, for people to have a general awareness of how these things work, where their data goes, who has it. I hope that means they also will take cybersecurity more seriously as well. But I think you're going to start to see a little bit of a shift from industry as well. I think industry has learned some tough lessons over the past couple months and years that will start to integrate in some of their approaches and how they make things, how they present things to consumers, how they make things more clear of what they're doing with their data and giving more choices. And I think, Chris, that's a point you made earlier that I think really stuck out. So
Good, and I also hope you'll help us support the EU Cybersecurity Act, but that can be a different panel.
Can I add one thing? It just occurred to me. How many of you are software developers or work with software developers? So one way you might compare and contrast the EU and the US approach is the EU GDPR approach to privacy is a lot like the waterfall software development method, where you basically design everything up front. And then you you test it, and then you put it into production, right? And so you try to solve all the problems. You try to get all the smart people in a room, and you design something, and you design it as perfectly as you can, and then you put it out the door. And then 5 years later, you update it. The U.S. approach is much more like agile development, or whatever buzzword people are calling it now. I can't keep up anymore. But it's where you do the core functionality, you do the core protections. What are we really aiming at? In the U.S., we're really aiming at making sure that consumers aren't injured. That's what we're aimed at, or deceived. That's what the FTC's approach is. And then we see how that works. We let people innovate. We let people try things out. And then when there's harm, we address that harm. So then we adopt a law that's focused on healthcare, or we adopt a law that's around children's information. And that's a sort of iterative process. It's much more agile. You see where the harm is, you focus on the harm, that is what you're aiming at. You're not aiming at some grand design for the world, because you know that in the real world, it gets messy. And if it gets messy in the world of bits for a small software project, so much that you can't design it ahead of time, you better believe that in the legal world, which moves much slower than software development, you're gonna just be lapped constantly by the developments in the world. And so the US approach, I think the common law approach there, I think is much better suited to an environment of rapid change that we have in the information space. So one way to think about it.
Thanks, Neil. So we're here in the Bay Area, and we have a lot of investors and developers in the audience. So one question that I have for you guys is precisely how might the California Privacy Act or comprehensive privacy legislation, were it to come about, affect those communities specifically?
Well, I'll just start by saying briefly, again, the point about the technical corrections and changes that need to be made. So I don't want to over-rotate too much on the exact compliance requirements that would be necessary for the bill as we have it now, because I don't believe that it will take effect in the form that it is now, one way or another. And then I will cite my other point, which is I think that many of the businesses that we are talking about, especially businesses that do have ambition to grow and to grow beyond the United States, already have to think about many of these things if they aspire to reach Europe and have European users because of the effectiveness of the GDPR. So I hope this is already on a lot of minds and a lot of radar screens, and certainly I know that some of the mailing lists I'm on have blanketed me with invitations to learn more about the GDPR and how to do GDPR compliance for the first 2 quarters of the year. And I've seen a lot of nods. I'm clearly not the only one. So I do think that there's an education process that had to be gone through for that, especially for American companies. And there may need to be a similar one.
Thanks. Anybody have anything to add to that?
I think I would just add that people are definitely spending a lot of time on GDPR compliance. They're spending a lot of money on it. They're not spending that on building products for consumers. They're spending it on compliance issues. And that's so the question is, is the outcome going to be better off for consumers in the end with that level of compliance costs, taking away from other types of investment? And I think it's a hard question, but I think it's one we'll see. I mean, maybe Europe will experience a giant boom in tech innovation.
I'll just add, pay attention to this issue. I mean, this is not going anywhere. This is going to get harder. It's going to get messier. It's going to get uglier before it gets easier. Make sure that you have strong privacy protections to start, so you don't get caught up in a lot of these things if you can help it. Make sure that when these debates are happening that you're participating. Make sure that you are, calling your member of Congress or your local official to say what this impact is going to be on your business, because they need to hear from you. I can, talk until I'm blue in the face, but a company that has actual experience and actual impact on jobs and on the economy has a lot more pull, and that's really helpful. So make sure that you're keeping that in mind as as we're going through this process.
Aside from the GDPR meditation app, what are some resources that people can follow or use to understand and follow this debate?
I suggest your local friendly trade associations. There are a lot of resources out there. Trade associations are one way. We're here to be a voice for you, a voice for the industry. We're here to be a resource. So, use folks like myself. There are other, the International Association of Privacy Professionals is a great source that I've used a lot, and I'm sure there are lots of law firms that are willing to help you as well.
I would say there's a lot of great resources, not necessarily on the GDPR. I don't know a ton about where you might go for that, although I know there's a lot of my friends who do privacy law who would be happy to bill you for giving you advice. What I would say is the FTC's website has a lot of practical advice on how to achieve some of these goals, again, in the soft law guidance category rather than in a statutory check-the-box compliance approach. And so I would suggest checking out that website. If you're interested specifically in the California privacy law, Eric Goldman at Santa Clara has done amazing work on this. His blog is, he sometimes writes too long of blog posts, but they are very comprehensive. And on this topic, he has really dug in deep. It's very insightful stuff. And then, Anne has actually done a lot of this work, and the people at Mercatus have done great work on this as well. And so check out Mercatus's resources on privacy.
So I'll add to that a little bit, again, in this sort of general awareness bucket, because I don't have specific GDPR references to suggest. I think a number of the organizations who have people up here speaking have mailing lists, and I would highly recommend subscribing to Mozilla's mailing list, R Street's mailing list. Does Mercatus have a mailing list?
Yeah.
Okay, they go with theirs too, because we do end up talking about these because they're such high-profile issues. So you can at least learn more and track how these things are going, following Jamie's advice, just to pay attention and be aware of the space. So let me put that in an even bigger context, if I could. Whether you agree with it or not, the honeymoon period is over, right? The essentially free rein that the U.S. government gave to technology companies for many, many years, that time is not coming back. So whether it's in this dimension or in content regulation, intermediary liability, the Stop Exploiting Sex Trafficking Act and its House equivalent FOSTA that passed earlier this year, across a whole number of dimensions, I would look for increasing efforts by the U.S. government to impose compliance and regulatory burdens on the technology sector in an attempt to address what many, many people believe are problems. Problems from that sector, whether economic, as per the last panel, whether social, whether political, whether structural. We can agree or disagree on whether these interventions are right or not, but I'm telling you they are coming. So if you are a small business, join a small business association, go to Startup Policy Lab events here in the Bay Area, talk to the people at Engine who are San Francisco based, who are great people. Like, get together so that you can see what's coming down the pike, so that you can be aware of it, because it's coming.
Thanks. So in a minute, we're going to go to audience questions, so start thinking of yours. But before we do that, I would like to leave a second here for the panelists. If you would leave the audience with one takeaway, what would that takeaway be?
I'm going to cheat because I'm not going to do just one, because I actually had a response to what Chris said. But one of the challenges in this space is that there are a lot of movements to regulate big tech, and they're in tension with each other. So, for example, the privacy compliance costs of complying with the GDPR or the California rule, it's expensive. It's hard. You know who can do that really well? I was talking to my friend, one of my friends who worked on the Google Chrome project when they were leading up to GDPR compliance, and he would get constant requests from the lawyers saying, "Hey, we need to implement this. We need to implement this. We need to implement this." And his takeaway largely was, "Oh, we can totally do this. Like at Google, we can do it. It's fine. It's expensive, but we can afford it." But man, I would hate to be working at a small company trying to do this stuff. And so, if it is coming, if our goal is increased competition, there's some negative side effects to this stuff. And if we want more competition in the tech space, putting regulatory burdens is a good way to suppress the competition. And I think, in fact, there's a lot of sort of currents that are happening in this space, and a lot of them are from competitors of these big companies, and who want to use these tools in order to compete, in the halls of Congress instead of in the marketplace. So, said that. My one takeaway really quick is that consumers value many things. They don't just value privacy. We need to respect their ability to choose among many things, and we need to not try to dictate to them the structures in which that they make those decisions. And think about emergent processes rather than top-down design, more agile development rather than waterfall.
Yeah, I think providing better clarity and transparency to consumers will go a long way. I think a lot of good faith efforts on the part of the industry is going to be really helpful as we go through this process, as we look at potential federal legislation in the next year or two. That can go a long way. And then my piece of advice of making sure you continue to pay attention and make sure that you're sharing your stories with us, with your government officials. It's going to be essential.
So I'll plus one to Jamie's providing more and more information, awareness, and control to users will go a long way. I think that certainly outside the United States, but increasingly inside the United States, privacy is something more than just one thing that consumers care about and one thing that they make choices on. It's something that many believe, perceive, and feel to the very core of their being as a fundamental right, and something that can't just be bargained over or folded into a stack of other things. And I think that's why we're seeing the trajectory that we're seeing all around the world, and even increasingly here. And I do think the market today is characterized by a lack of sufficient awareness and choice to exercise meaningful and granular consent over the way that data is being collected and used and transferred to third parties. And I think that although there are steps being made in the market to help address that, they're not going far enough. And that's why I very much believe that we're going to continue to see intervention.
All right, so we're ready. We have about 9 minutes for audience questions. Please phrase your question in the form of a question. Thank you.
Oh, never mind then.
Not allowed to let go.
I see. I understand.
If I give them the microphone.
Oh, I see. All right, no problem. So why do you keep using, I'm going to make this as short as possible and as provocative as possible. Why do you keep using privacy and data protection interchangeably in this discussion when, in fact, and I know you know, Chris, that GDPR covers publication of public information and collection of public information that has, including information that may be have been published in newspapers or elsewhere in the world. Why? Look, let's stipulate, if we stipulate that privacy is really, really important, why are we not talking about the suppression of public information that almost certainly will happen under implementations of the GDPR?
So I do not mean to conflate those two terms. To the extent that I was, well, I had to have to rewind and watch myself on video to see, but I do. There is a distinction between the two, for sure. I think that privacy as a term is maybe used more broadly by many people than you were using that. So I would push back on you in that respect as well. The General Data Protection Regulation is, of course, one piece of privacy law within the EU. We could have an entire panel talking about the e-privacy regulation and the things that it does and how that differentiates from data protection, which is focused specifically on the collection of the collection of data, the use of data, the transfer of that data, as opposed to many different other pieces of the broader privacy umbrella. But I think that you're missing part of the equation here by saying that privacy should only be focused on information which is not made available, right? Or not made publicly available is part of how you said that. Like, I think that that's too narrow a lens for how users experience and expect their privacy rights to be protected.
Does anybody else on the panel have comments in this regard?
Well, I would just say that there's another entanglement that often happens between data security and privacy. Those are two very different issues. And in fact, in the data security space, where we're talking about misuse of data, there's a general agreement about what a good world would look like there. When we're talking about privacy, which is about how my interactions with other people or with a website or with a series of websites, how I control that or how who has the rights to that. We have radically different. There's many people with radically different views about how a good world would look like. And so when it comes to regulation, when it comes to legislation, if I was going to say one was easier, I think the data security one is probably easier because more people agree on what a good outcome looks like than do on what a good outcome on privacy looks like. Some people are very, very private. They don't want any of the information flows from them being out of their control, as impossible as that is. Some people are very free and very open and want that information to get out there, and they want to share information in a way that they know benefits them. And so, yeah, I'll just end there.
Thanks. Another question?
Question here.
Thank you all so much. I'm wondering if comprehensive legislation were to be implemented, would states be preempted from making additional regulations? And another way to say this might be if comprehensive legislation were implemented, would it be viewed as a ceiling or a floor in terms of preemption, and what effect might that have on usability?
That is a great question. Anything that we would be supportive of would have to be preemptive. As I mentioned earlier, with the problems that we've seen from 47 different data breach notification laws, we can't have that happen again. We can't have that happen on privacy. So one national standard, it makes a lot more sense for how we do business, how we things don't stop at state borders. So yeah, definitely a ceiling more than a floor. Otherwise, it's just one more layer on top of another that just makes things more complicated.
Do we have another question?
Oh, okay. Hi, I'm Sean from Fast Company. I've got a question. This has been really informative, and I really appreciate getting a sense of implementation. What I'm curious about is there any agreement in the world or on the stage about sort of what might be like a couple of fundamental principles of privacy, like truths that we hold self-evident around that?
It's a great question. I can't. I don't know how we're going to work that out. To see, I'll throw out an idea of something I think we probably all agree on, and then you guys can let me know. I think we all agree that we don't want consumers to be injured by how their information is used. The question is, how do we get to that? And the FTC's approach has been very much to focus on the injury, to focus on the harm or the deceptive practice there, and rather than focus on the process by which we might design a world that prevents that harm. And so if we focus on redressing that harm, and also, use this as a deterrent effect on companies who know that they may face a lawsuit from the FTC if they harm consumers. That approach has been pretty successful, and I think it aims at what we're trying to really do, which is prevent consumer injury. I don't know if you guys agree with that.
I agree with you there.
Yeah, another thing to watch would be the conversation, what NIST is going to do in convening stakeholders to develop a voluntary privacy framework. That's actually going to be
NTIA as well.
Yeah, exactly. That's going to be
FTC.
precisely an answer to the question that you asked, but with industry stakeholders also involved.
Chris, do you agree with consumer injury as the goal? Preventing consumer injury?
I mean, to the extent that you're framing that as a floor, I think that you could probably go a little bit further even and say something along the lines of, I think we all believe consumers need to understand what's going on. And I think the degree of specificity and granularity to which we think they should be informed is probably an area where we would disagree. But I think the general principle of consumers needing to understand what's going on is probably universal. And certainly, to some degree, an ability to choose, even if that choice is limited to not being part of the service or being part of the service. I think that's probably a fundamental baseline principle. Certainly, we believe that power of choice should go further than that, but I think that probably consent and choice as super high-level principles are things that get quite a lot of buy-in at this point.
Yeah, I think you're right. I would say the idea that consumers need to know what is going on has to reflect the idea that a consumer's attention is a limited resource. And if you're forcing consumers to pay attention to one specific thing that's going on, privacy stuff that maybe they do or do not care about, you're taking that resource away from them in another way that they might have directed that limited resource. And so when we say they need to know what's going on, yes, but they should be the ones choosing what they need to pay attention to, and not us.
Can I give a specific example that I think actually makes your point that you probably like? And that's the way that the e-privacy directive in Europe is currently implemented. Now, I'm not saying that's the way it needed to be implemented, but the way that it's implemented today is via the cookie banner. So when you browse websites in Europe, there's a banner at the top, nobody reads it, you click OK, and then you continue using the website. And I don't think any of us feel like that's an effective implementation of a meaningful privacy regulation. We'll just put it that way.
All right, with that, I'd like to thank our panelists and turn it over to Garrett.
Thank you very much. You can leave the microphones on the chair. Perfect. Thank you.